hate calling people this, but what you did was just stupid. What Mrs. Gaines says is what you should have realized, and that is you go in, it goes off, you get out. You just go. That means somebody gave you a ride there, that's fine. But if you got to just hoof it out of there, you just get out. Understand?
Yes, Your Honor.
Because see, because of this, you spent what, 17 days in?
18.
Okay. You spent 18 days in, you didn't have to. Right? You gotta use your head, right?
Yes, sir.
Court was that certain things were said. The other report did not show a call from this defendant to community corrections or anything. It didn't say that he did anything. Sponsor, I think I brought that up at the last hearing we were at. That I saw nothing that he then did. What it seems that it turned out is that he did do something. He probably should have called JSG, but that's okay. He called community corrections. So that's a big change in this court's mind. But the other thing that's a big change is that there was nothing that verified why the defendant was in here. One story, but there was, at the time of the hearing, it was being said, but there was nothing that indicated that he had told anybody that. What's clear to me is that if he's contemporaneous with the encroachment into the zone, he then calls, says, "This is what I'm doing." Doesn't seem to me under those circumstances that that's something that's made up. Plus, he's in that zone for what could be a significant period in time, depending on what he's up to. But it wasn't as though he went into that zone and spent half an hour. That's not this case. The problem is all right, what I'm going to do, he had admitted to the violation, and it is a violation. Randomly, I'll sentence him to 18 days, Western County Jail credit 18 served. His previous bond is reinstated with including all of its conditions. And yes, tether, I'm not going to make it home confinement. I'm going to make it location track home. I don't know if the home confinement does anything. All right.
Thank you.
And sir, you understand now what you have to do.
Yes, Your Honor.
Right? Yes. All right. Keep the number to JSG and to well, you know the number for community corrections, but get that number for JSG and keep it with you just in case. Okay.
Thank you, Your Honor.
You're welcome.
Thank you, Adam.
On that case, what are we doing on that one?
Do we approach?
Hold on.
Bond motion and a few things we would like to emphasize and information that I received from my fellow counsel. Mr. Brown indicated that he and/or Ms. Pate had spoken to community corrections and were able to confirm that Mr. Smith contacted the community corrections front desk and spoke to them about about what was happening when he was in the exclusion zone. Yeah. So that's the first thing. And so they were able to confirm that is the information I received. The second.
Well, and I know this wouldn't be you necessarily. Mr. Brown came up at a bench conference, stated that I said I needed something in writing.
So it was my understanding from the notes that the agent said that he was going to submit something to you directly, and I will take a look at that and give you the date that conversation.
Which conversation?
The conversation where the agent told, I do not recall if it was Miss Pate or Miss Mr. Brown that they would submit something to the court directly.
You received anything from community corrections on this?
So on April 20th, I take it back, it was Miss Virgils spoke with Brian Levitt, who said he'd amend his bond report with updated information. And that he did not contact the client, that is, not contact the bond, or pardon me, the tether agency directly, and the tether company did not contact him, but client called community corrections. And there is a cut and paste of an email to Miss Virgils from Mr. Levitt that says, for clarity, I was misinformed prior to our conversation. Terrence Smith Jr. did not call JSG Monitoring, nor was he contacted by them. He called Community Corrections and spoke with the front desk officer regarding his violation and stated he was with his cousin helping him move. I will amend my report with that information as well as what else you require.
But I don't have an amended report. I don't have anything.
So I was under the impression that that had been provided to Your Honor based on my conversation. If we could pass for a moment, then I will out my conversation with my colleagues. I will reach out to Ms. Levitt. I will also attempt to get a copy, original copy of the email so that you will have that as opposed to me just reading it from Mr. Levitt.
We emailed on April 20th. Up to you.
You don't have anything either.
I do not have an updated report. The only report that I have from Mr. Levitt, I received, looks like on April 14th.
So, right, I have is one dated April 14th. But I guess part of the change is, particularly the third or fourth paragraph down, that he called community corrections today in violation and spoke to front desk stating he was helping his cousin move, which I don't think was contained in the original.
No, and I don't see that I have that language.
Mr. Neal. That was sent to us on April 20th, or thereabouts. Oh, I don't have any timing on that or anything, but I get it. Okay, go ahead.
The second thing that we would like to add orally to our written motion is that Mr. Smith has had a had time to really think about this and his and what he could have done differently to not have been in this situation. He's taking responsibility. He indicates that he could have and should have gotten more information from his cousin before agreeing to help with the moving, because he did not know it would be in the exclusion zone. He also states that he could have and should have left as opposed to staying area for the 8, and walked away as opposed to trying to get his cousin to, and what eventually happened, his cousin giving him a ride away from the exclusion zone. The last thing that he's learned, and he said, he and his cousin and his friends and some of his cousins, some of his friends have not always been the best influence. And that he has really learned from this that the people that he thought were not for him, his parents, are really the people who have been for him, and that he needs to take their constructive criticism, and because they've been the people who have put money on his books, who have been supporting him with this. So he is asking that the court please consider, as part of this, that he learned a very harsh lesson, a very harsh manner, but that he has very much so learned this lesson, and that he and that you will not see him in that exclusion zone again.
He's been in since when?
He has been in since April 13th.
All right. Mr. Cook.
Your Honor, I primarily rely on the written response to add just a little bit to that. With that additional report, somewhat corroborate about the defendant helping his cousin move. I think that does give the people a bit more, trying to think of the proper words to use here. I think that helps lessen my concerns as it comes to the victim's safety with that additional information provided from community corrections ability. So it comes from the defendant, but at least shows that he did contact them day of. I think if the defendant were to be released on tether, I understand the victim is not at that original address anymore. I think it might be good to the middle of the round. Just reinstating the bond as it was versus I would feel fine with keeping that in.
But prior to this occurring, we had not had any violations. He was on a tether where he could move around.
That is correct.
I believe that's correct.
Okay, fundamentally, the issue for the court was that certain things were said. The other report did not show a call from this defendant to community corrections or anything. It didn't say that he did anything. And I think I brought that up at the last hearing we were at, that I saw nothing that he then did. What it seems that it turned out is that he did do something. He probably should have called JSG, but that's okay. He called community corrections. So that's a big change in this court's mind. But the other thing that's a big change is that there was nothing that verified why the defendant was in here. One story, but there was, at the time of the hearing, it was being said, but there was nothing that indicated that he had told anybody that. What's clear to me is that if he's contemporaneous with the encroachment into the zone, he then calls, says, "This is what I'm doing." Doesn't seem to me under those circumstances that that's something that's made up. Plus, he's in that zone for what could be a significant period in time, depending on what he's up to. But it wasn't as though he went into that zone and spent half an hour. That's not this case. The problem is and I hate calling people this, but what you did was just stupid. What Mrs. Gaines says is what she should have realized, and that is you go in, it goes off, you get out, you just go. And that means somebody gave you a ride there, that's fine. But if you got to just hoof it out of there, you just get out. Understand?
Yes, Your Honor.
Because because of this, you spent what, 17 days in?
18.
8. Okay. You spent 18 days in and you didn't have to,
Your Honor.
right? So you gotta use your head. Right?
Yes, sir.
All right, what I'm gonna do, he had admitted to the violation, and it is a violation. Randomly, I'll sentence him to 18 days. Washington County Jail credit 18 served. His previous bond is reinstated with including all of its conditions. And yes, tether, I'm not gonna make it home confinement, I'm gonna make it location track home. I don't know if the home confinement does anything. All right.
Thank you.
And sir, you understand now what you have to do,
Yes, Your Honor.
right? Yes. All right. Keep the number to JSG and to well, you know the number for community corrections, but get that number for JSG and keep it with you just in case. Okay.
Thank you, Your Honor.
You're welcome.
Thank you, Adam.
On that case, what are we doing on that one?
Do we approach?
Hold on.
Okay, Your Honor, on behalf of Ms. Lavaz, we're requesting jointly a 3-week adjournment of the PCC because discovery is still being provided and investigation is still ongoing.
That we negotiate.
Okay. 21st?
Yes,
All right, May 21st, 2026, 9 a.m. Bond will continue.
very good. Thank you, Judge.
Court calls the case People versus
Ricarte,
Carthy.
John Shea, on behalf of Mr. Ricarte, who I believe somewhere in Boomland. There he is. Isidro,
Hi,
can you
I'm here, yeah.
name for the record?
Isidro Ricardo.
Thank you, Isidro. Your Honor, Mr. Kennedy advises me that I'm getting supplemental discovery today. I haven't received it yet, but I have no reason to, I have every confidence that I'm going to get it sometime today, but I'm going to need some time to, if I could ask for a 2-week adjournment of the piece.
One at the 14th or the same day as the other one.
We could do it on the same day as the other. That would be great.
Court will adjourn this matter to May 21st, 2026, 9 a.m. On continue.
Thank you, Your Honor.
Thank
you.
Isidro, I'll give you a call later. Thank you.
Court calls the case People versus Tayshaun West.
Thank you.
Good afternoon, Your Honor. Brittany Cook with People.
Yes, and good afternoon, Robert McCoy on behalf of Mr. West, who is coaching. Oh, and then I have my law clerk. I wanted to introduce her, Mira Osborne. She's about to graduate from Detroit Mercy Law School.
From where?
Between Mercy.
Sure. Well, sorry. All right. Your name, sir?
John West.
Actually, I have nothing against her. See, I don't know why I said that. Because I tagged. All right. What are we doing?
Yeah, we were going to be asking for an adjournment for some additional discussion, negotiation. I would also ask.
All right. And how much time would you need for the
3 weeks.
about 20?
No, I think, because I did talk to the officer, I think maybe, could we, maybe a couple months?
A month?
Well, there's something
A
else.
month? This is a new law student. You're gonna future lawyer. You're teaching that. A month?
We're trying to get some other issues resolved.
There's some county investigations going on, but I don't know the time frame.
Why were you helping? You want the 28th then? May 20.
May 28th. Yes.
Okay, May 28th, 2000.
Oh, I do, wait, I have something at 10 o'clock on May 28th.
Will you be done by say 12:30?
It's a family law case. So it could be, then I
Is
have,
that a no?
that's,
Hang on.
you know what?
You know what? No, here. You want to do June 4th?
Let's, see, because I'm looking at this family law stuff. This,
You're killing me, McCoy.
if we can,
Which day do you want?
you know what? Let's see, maybe the 28th, if it's like a 12:30 or 1 o'clock,
We'll figure it out.
we'll figure it out.
All right.
Not, it'll be Mr. Taylor coming over here.
Probable cause will be adjourned May 28th, 2026, 9 a.m. Esteban.
I would be asking the town to court order GPS tracking tether. The reason for this request, I spoke with a detective sergeant out of the Beverly Hills Public Safety. He informed me this morning that there's ongoing investigation into a string of larcenies from various automobiles in their county. As well as I received a report indicating that last Saturday, April 25th, the defendant may have been involved in scouting out a house for a potential home. There's no charges that have been brought yet. I'm not asking for the man, but given this additional investigation, a GPS tracking tether would be in the interest of public safety.
And Your Honor, I did talk with my client about that. He has, there's a mother, he has his expecting baby, a mother, and he was trying to find her. She sent him this address. He went out there to find her. So I talked to the sergeant and told him we were going to submit that information to him. And then he said that they're going to look at it, evaluate it, and let us know what they're going to do about that. So, so for that reason, we would object to the tether, because he said he was going out there to find the mother of his child who was expecting a baby.
All right.
They've got
other things that are being investigated are similar to what the allegations are here.
I don't know the full nature of what's out of county. My understanding based off the conversation with the detective sergeant is that there's been a string of larcenies from automobiles where things have been stolen, and that there's a group of individuals that they believe are perpetrating those, that the defendant is involved with that group. That's the full extent of knowledge I have about that investigation. And I would just note that as it relates to the incident from this past Saturday, the time that the defendant was at this house was at 2:23 in the morning. And at least according to some of the ring camera shows the defendant looking into the house, and there's a chair moved right underneath the windows if someone stepped up to look into the windows for scouting at the house. So I'm concerned about the claim that he's looking for the mother of a potential child. It seems a bit incredulous.
Well, I did talk to Sergeant Brewster on the case, and my client is forwarding those texts to me. He said that he was looking for the mother of his child. She told him
2 o'clock in the morning.
she said, this baby daddy, baby mama drama. He said she told him, he said that she said she was at an Airbnb and he was looking for her. He's like, where are you? You have my baby. She sends him this random address. He goes out there to find her, and that's not the same as somebody just looking in windows to do stuff. That's different. He's looking for his baby mama and the baby. Well, the baby to be. He knows he knows he's on bond to this court. So, I've encouraged him to find other ways to deal with that relationship.
Find some other way, but at this point, I am going to put a tether on him, given out both of those circumstances.
Okay.
Defendant is to report over to the Department of Community Corrections for placement of GPS tracking tether.
Okay. And
Might
then,
as well do it before you leave here.
okay. And then, Your Honor, he does work. He has 2 jobs. He works 7 days a week. So he works at the hair salon, and he also does custodial work. So we want to make sure that the tether is able to make, because he has another child, a 2-year-old. So he works and he wants to be able to go to work. What are your hours?
Wednesday through.
Well, I'm not. Want me to lock him down in his house? I'm not asking for that. I don't think
Okay.
we're asking for that. This is just a GPS location tracking. We're just going to know where he is.
Okay, that's fine.
Thank you.
All right.
Yeah. No. Yep. You said he would? No, you see. You know at least where you're going. You know where she is, right? And her name. Hey, oh, here, her. Okay. Court calls the case of the people versus Dana Fletcher.
Attorney Mark McManus on behalf of Dana Fletcher. Speak your name.
Dana Fletcher.
All right. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor, there has been an amended complaint. I'm not sure if we have to do that first before the plea.
Well, hold on. I thought we did it last time where there was what?
It was filed with us after.
It was filed after the last hearing.
Yes.
All right. And so that's the count 3, which is the operating while intoxicated second offense. Counsel, as to the arraignment on that, your client waives formal reading and stand.
He does, Your
Yes,
Honor.
sir.
Thank you. Yes.
All right. And so court will enter a not guilty plea as to that added count 3. But that means, hold on a second.
Count 2 was deleted.
Count 2 was deleted, but count 2 was the operating while intoxicated. I just want to make sure that his bond conditions match a drinking and driving offense, but I think they do.
They do, Your Honor.
All right, very good. All right, so now we have that. The plea form indicates that the defendant will be pleading to count 3, the operating while intoxicated second offense, the 1-year offense, and an added count 4 of use of a controlled substance, that being fentanyl, the 1-year offense. Upon a successful plea to those charges, count 1 would be dismissed. That is the court's full understanding of the agreement. Is that correct, counsel?
It is, Your Honor.
All right, very good. Sir, if you can please raise your right hand to be sworn.
Speak loud.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again, please, sir.
Dana Fletcher.
All right. Sir, it is this court's understanding that you're going to be pleading to 2 misdemeanor charges. The first being the stated count 3 of operating while intoxicated second offense. That's a misdemeanor punishable by up to 5 days to 1 year in jail, up to a $1,000 fine plus court cost. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
The other charge, the added count 4 of use of a controlled substance, that's a misdemeanor punishable by up to 1 year, a $2,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. Understand that?
Yes, Your Honor.
Understanding all of that, to the charge of operating while intoxicated, second offense, how do you plead?
Guilty.
To the charge of use of a controlled substance, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, sir.
If you see a copy, looking at paragraph 5, those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as other rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you are indeed guilty of these offenses?
Yes, Your Honor.
On the date of December 31st, 2023, at the location of US 23 near Nixon Road in Ann Arbor Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you ingested a controlled substance?
Yes, Your Honor.
And what had you ingested, sir?
Fentanyl.
All right. And did you know that what you were ingesting was fentanyl?
Yes, Your Honor.
All right. Were you stopped by the police at some point?
Yes, Your Honor.
All right. Why'd they stop you?
Speed. Speed.
All right. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital for a blood draw?
Yes. Yes.
All right. Did the results of that blood draw show the presence of fentanyl and or its derivative in your system?
Yes, Your Honor.
Do you have any reason to dispute those blood test results?
No, Your Honor.
All right. Had you previously been convicted on or about, January 20th, 2021 in Bowling Green, Ohio, of the offense of operating under the influence of alcohol or drugs?
Yes, Your Honor.
All right. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
You are satisfied.
We are satisfied, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Count 1 is dismissed. Pre-sentence investigation and report and screening and assessment is hereby ordered at 14A2 probation. Sentencing in this matter will be May 26, 2026, 10 a.m. before Judge Barr.
Thank you very much, Your Honor.
Thank you. Bond with its conditions will continue. Thank you.
Thank you very much, Your Honor.
Court calls case of the people versus Desmond Hodge.
Good afternoon, Your Honor. Raymond Cook.
Good afternoon, Your Honor. James Feifelsky appearing with and on behalf of Hodge, who is approaching. You state your name, please.
Desmond Hodge. Oh, quick.
Judge, I believe all discovery is in. To the best of my knowledge, we'd ask the court to set this for a preliminary exam.
And Your Honor, I sent 2 emails yesterday. One of them, I initially thought there was no additional discovery. The agency got back to me and said, actually, it was under a different case number. So there may be additional video that has not been marked yet. I only just got that video. I don't know if it's for this case or if it was for a different case because I haven't had the opportunity to watch it yet. It's a couple hours long, but there may be more discovery that's still needs to get sent.
If the court can set this out, we're comfortable moving forward with what we have, understanding if there is additional discovery, it'd probably show up within the next week or so.
Hopefully week again, there's about 4 hours and they do start a trial Monday next week. So isn't agree with that.
You think there's 4 hours of video?
That's why I saw on the timestamps at evans.com, there was numerous videos. I added up quickly before.
All right, I'm gonna adjourn the probable cause. Let's get the discovery and if there's 4 hours of video, gonna at least have to look at it. I'm gonna adjourn it out to May 14, 2026, 9 a.m.
Your Honor, I am seeing that I believe my client has a review hearing. Well, if it's later in the morning or 12:30, it'll work. He's got a review on a case that arose from the same date and time in 14B, for which he's on probation. That's at 10 o'clock, so I think we'll be okay.
For this gentleman?
Yes, Mr. Hodge.
Okay, so theoretically, unless you had somebody in custody, you're gonna be in this block, so he shouldn't be
That will
14B that long and be able to get over.
that'll work out perfectly. Okay, thank you.
All right, thank you, sir.
Well,
14. Court calls the case People versus Barrett Donovan.
And people, Your Honor.
Good afternoon, Your Honor. Allison Castles appearing on behalf of Mr. Shanman, who is appearing by Zoom.
Gentlemen, can you state your name, please, sir?
Barrett Shanneman.
All right, I have before me a plea form that indicates defendant's going to be pleading to the stated count 2 of domestic violence, a 93-day offense. Upon a successful plea to that charge, count 1 would be dismissed. There's also an agreement to sentencing under 7694A. That's the court's full understanding.
That's correct.
Okay. Sir, can you please raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, state your name again, please.
Barrett Shanneman.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of domestic violence. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
Understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No.
Looking at paragraph 5, those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On date of December 3rd.
If I may, dear Mr. Shanman.
Sure. Hang on one moment. On December 3rd, 2022, location of 3183 Randolph Court, Pittsfield Township, Washington County, State of Michigan. Now you may wander.
Mr. Shanman, on or about this date, were you in a dating relationship with the complainant, Jessica Pascua?
Yes, that's correct.
And on or about that date, did you shove Miss Pascua?
Yes, I did.
And did you have her consent to do so?
No, I did not.
Were you acting in self-defense?
No, I was not.
If the court's satisfied with the factual basis.
All right. And you did it on purpose. It was not an accident. Is that correct, sir?
That is correct, Your Honor.
All right. Sir, I would have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, I understand, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation court is ordered at 14A1 probation. Sentencing in this matter will be
May 18th, 1 p.m.
May 18th, 2026. I'm sorry, what?
1 p.m.
1 p.m. before me. Yes.
And is that on behalf of the people, Your Honor?
Good afternoon, Your Honor. Ivan Land of P65879, appear on behalf of Mr. Christopher Johnson. Please state your full name for the judge.
Christopher Johnson.
Thank you.
Yes, for the jury. There's a couple of things I need to look into before I really get this case forward. So I'm asking for 2 or 3 weeks.
We have no objection, Your Honor.
May 21st work for you?
I will, Your Honor.
During the matter, May 21st, 2026, 9 a.m. or as your invite indicates.
Always a pleasure, Your Honor. You and your staff, stay safe. Yep, take care.
Thank you, Your Honor.
Court does call the case, People versus Enna Gurma.
As with all the people.
Good afternoon. Judge Christopher Quinn, appearing on behalf of Ms. Gurma.
All right. I have before me a plea form. Is that what we're doing today?
That's correct, Judge.
All right. Plea form indicates that defendant will be pleading guilty to a charge of use of a controlled substance, that being cocaine. That's the added count 2, the 1-year offense. Upon their successful plea to that charge, count 1 would be dismissed. There's a sentence agreement to sentencing under 7411. That's the court's full understanding of the agreement.
Yes, sir.
That's correct, Judge.
Have her sworn?
Right. Tell them swear and affirm the testimony about to be the truth, the whole truth, and nothing but.
Yes.
Thank you, please.
Edna Gurma.
All right, Ms. Gurma, it's this court's understanding that you're going to be pleading guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court. Do you understand that? All right. You understand also, ma'am, that while I'm taking it, I would not be your sentencing judge, and you would be sentenced before Judge Garwood in the 15th District Court. You understand that?
I do now.
Yes. Right. Okay, you understand that I'd take the plea, but I wouldn't have anything to do with it afterwards. You said before Judge Garwood.
Okay, I have a question.
Uh-huh.
You say would take the plea?
I'd be taking the plea right now.
Okay.
But you'd be sentenced before a different judge in 15.
And what do they sentence me on?
What'd you say?
What
They said a plea agreement, the plea agreement.
they're gonna sentence the plea agreement?
Well, yes, all right, what's your worry?
I'm trying to understand why I gotta go. Okay, what?
Why you gotta go to another judge? Okay, because I'll just define it this way. The district court judges, we combine certain parts of our docket, which is this is part of, right? But our misdemeanor dockets are based upon what jurisdiction we sit in.
Oh.
Okay. So Judge Garwood sits in the city of Ann Arbor, which is where this occurred.
Okay.
So while I'll take the plea, that's where you will go for sentence.
Yes, sir.
Does that make sense?
Yep.
Okay. God, that was beautifully the way.
Ooh.
No, I don't think I've ever had to explain it. I leave it to Miss Gurman to make me do that. Anyway, all right. So you understand all of that,
yes,
right? Do you still wish to plead guilty?
Am I pleading guilty? Yeah. Yes.
Okay. So to that charge of use of a controlled substance, how do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Uh-huh.
You understand that? Okay. You signed an advice of rights for me, right? Is that correct? Okay. You have any question regarding any of those rights?
Nope.
All right. On the podium, you'll see a copy of one. Look at paragraph 5. Now, those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Yeah.
Okay. You understand you're giving up your right to appeal of right.
Mm-hmm.
Is that a yes?
Yes, sir.
Me, a yes or no? All right.
Yes.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will? And also because you believe that you are indeed guilty of this offense?
Yes.
All right. May 2nd, 2024, at the location of 100 South 4th Avenue in City of Ann Arbor, Washtenaw County, State of Michigan. Cocaine in your possession.
Yes.
Had you used it? Did you know what you were using was cocaine? All right. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentence, if you,
Thank
between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that you would not be entitled to withdraw your plea. Understand that? And the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
Okay. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Judge.
Okay.
And have I complied with the court rule?
You can watch that slide.
Yes, Judge, you have.
Court will accept the defendant's plea to count 2. Count 1 is dismissed.
Your Honor,
That's
it's
right.
gonna be a misdemeanor, right?
Yes, it's a misdemeanor.
Thank
All right.
you. Okay.
Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
May 26th at 9 a.m.
May 26, 2026, 9 a.m. before Judge Garwood,
They got that still.
right? Bond will continue. Thank you.
Thank you, Judge.
Do I still have to drop every week?
You have to continue, your bond conditions will continue until Judge Garwood says bye. You gonna wait for me to answer? Sir, no, I'm still answering you. You just turn your back and start walking out.
I'm sorry.
No, you're not. No.
I
Okay. All right. You just got to continue to, I don't want you to get in trouble. So keep doing everything until Judge Garwood says something different.
Okay.
Okay?
Thank you.
Take care. Hey. So, why didn't you get a change? Yes. Right? Mm-hmm. What happens when you do that, Clinton? I'm not talking to you anyway. Court does call the case. People versus Hunter Hartline.
As they call it.
What? Oh.
And good afternoon, Your Honor. Megan Stammel on behalf of Mr. Hurtline. I'm just trying to figure out how to start my video. And I do
There you
see my
go.
client,
Got it.
there we go. And I do see my client present on Zoom. I'll ask him to state his name for the record as well.
Hunter Hurtline.
Okay, there you are. All right, what are we doing today?
Your Honor, I've been in contact with the newly assigned assistant prosecutor on this case. I provided her with a bunch of information that I previously provided to the previous assistant prosecutor. It's my understanding she does need some additional time to look into our request for a resolution in this case.
All correct, Your Honor.
Well, May 21st work for you?
Yes, please, Your Honor.
All right, I'll adjourn this matter May 21st, 2026, 9 a.m. as your invite indicates. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Quadric Gilliam.
As resolved for the people.
Hey, Judge. Worship JusticeSystem Public Defender on behalf of Mr. Gilliam, who's on Zoom. Gilliam, please state your name for the record. Thank you, Judge. I believe Mr. Gilliam wants to set this matter for preliminary examination.
All right. So the preliminary is all discovery complete?
To my knowledge, Judge.
All right, would people have their witnesses available to 12?
Correct that date, Your Honor. Thank you.
All right. Preliminary examination will be set May 12th, 2026, 9 a.m. That is before Judge Moore.
Thank you, Judge.
All right, bond continued. Court calls case People versus Taylor Godfrey.
Your Honor, Raymond Cook for the people.
Good afternoon, Your Honor. What is the speak of the Godfrey?
Your Honor, we are in,
Taylor Godfrey.
Thank you.
Your Honor, we are in the midst of ongoing negotiations. We would ask for a short adjournment. Thank you.
Without objection, probable cause conference will be adjourned May 21st, 2026, 9 a.m.
Thank you.
Thank you. Bond continue. Court recalls case of the people versus Cody Lee Bowman.
Good afternoon, again, Your Honor. Raymond Cook for the people.
Good afternoon, Your Honor. Good afternoon to your staff. May it please this honorable court. My name is Todd Russell Perkins, P 55623, appearing on behalf of Mr. Bowman. Mr. Bowman, can you unmute yourself and give your name, please?
Bowman.
All right. Thank you.
Your
All
Honor,
right. What are we?
I'm sorry.
No, it's okay.
Oh, okay. Your Honor, I've been in touch with the administration, with Katie and the office as it relates to a possible resolution in this matter. I think it might take a little bit of time. And I do have a couple of trials, one out of state. So I'd be asking if I could come back on the 28th, Your Honor.
See, I've just been Perkinsed. You know what I'm saying, Ian? He went through all of that, sounded real nice, everybody's just caught up in his eloquence. And then he just throws that date in like way out there.
Yeah.
That's okay. Yeah. I'll take it. Probable cause conference will be adjourned May 28th, 2026. 9 a.m. or you're invited to case. Bond will continue.
Thank you so much, Your Honor.
And
Always
I'm just teasing you, Mr. Perkins. Always
I
a pleasure.
enjoyed it. And one of these days I want to represent you when you get into Hollywood.
Oh, exactly. I thought he thought I was going to pick up a case.
No.
I didn't know what he was going to say.
Oh, no. No, we're going to pick up some contracts.
I got you. Okay.
Yeah.
Thank you, sir.
All right. Thank you.
Thank you, Your Honor.
All right. Thank you, sir. Court calls the case. People versus Zaya Greer.
Good afternoon, Your Honor.
Hello.
Hi,
What's your name?
Zaya Greer. Your Honor, Mr. Cook and I have been discussing a resolution for Ms. Greer as well. We are asking.
Nice to.
He's been pretty nice.
Oh,
Yeah.
second.
Yes.
Just check.
Never not been nice to me.
All right. How much time did you guys need?
Could we get it about 3 weeks? We're trying to get restitution
Set. Okay.
set, so.
All right. I will adjourn the matter to May 21st, 2026, 9 a.m.
Thank you.
All right. Thank you.
Ms. Black.
Court calls the case versus Christopher Griggs.
Assistant Public Defender Davi Lebo for Mr. Griggs.
Is he here?
Mr. Griggs.
Carlos Griggs? Christopher Griggs, I'm sorry. Nope, not here.
Your Honor, I have been in contact with him, so I'm surprised that he is not here.
Never mind. Bench warrant will issue for defendant's failure to appear. Bond to send him out of 10,000 cash surety. That warrant will issue immediately. Right there. Oh, that's what I do on these. I get, if you're right. Thank you. Court calls the case, People versus Robin Hardy. It's only for Webster.
Joy Gaines, Senior Assistant Public Defender representing Ms. Hardy, who I believe is participating by Zoom.
Ms. Hardy?
Yes.
Okay, you got her.
Okay.
Okay. State your name, please.
Robin Hardy.
Thank you.
And I some information from Ms. Hardy that I supplied to Ms. Beltez late yesterday. And so I'm asking for an adjournment so that she'll have an opportunity to do that and hopefully come to a resolution.
Probable cause conference, May 21st, 2026, 9 a.m.
Thank you, Your Honor.
Bond continues.
Thank you, Mr. Allen.
Thank you, Your Honor.
Court
May
calls case-
21st.
Yes, ma'am.
Okay, thank you.
Thank you. Court calls the case People versus Jordan Harris.
Good morning, Your Honor, or afternoon. Stephanie Cannon on behalf of Ms. Harris. Ms. Harris, you are present.
Yes, she been over.
Name for the record. I'm sorry, what, Your Honor?
How long you been over there?
How long? I've been
Been sitting over there?
the whole time.
Really? As quiet as you've ever been. Go ahead.
Just an act. Your Honor, we're asking for an adjournment of this matter, just for a couple of weeks for plea negotiating process. Write it down. Your next.
Probable cause conference will be adjourned. Be May 14th, 2026, 9 a.m. Bond continued. Court calls case People versus Robert Harris.
Helps for the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Harris, who should be in appearance via Zoom.
Yeah, I'm here.
Robert Harris. Oh, hold on. State your name.
Robert Harris.
Okay, you got him. Okay. All right.
And
Go
Your
ahead.
Honor, we are very close to working out a resolution on this matter. A resolution up in circuit court. We were just trying to figure out the terms of that. So we would ask for a brief adjournment in order to do.
Probable cause conference will be adjourned to May 14th, 2026, 9 a.m.
Thank you very much. Mr. Harris, I'll be in touch.
All right. Thank you. Thank you.
Thank you, sir. Court calls case People versus Daniel Heelan.
Yes, Judge. Oh, he's here. Ready for assistant public defender on behalf of Mr. Eland. Looks like he is on. Judge.
Yes, he is. Sir, state your name.
Well, we tried to reach out to Mr. Heelan.
Hold it. Did he say his name? Okay, you're gonna have to take those headphones off because that's not gonna work. Well, you gotta turn them off because we can't hear you.
Okay. How about now?
There we go. Yep, we can hear you now.
Thank you, Judge. We reached out to Mr. Heelan and did not have any contact with him. I did not know he was going to be here, but I'm glad to see him. I am asking for an adjournment and asking that he call our office so that we can have a conversation about his case.
Has he been testing?
I do not know, Judge. Mr. Heelan, have you been testing?
Hold it. You were in Bear River, right?
Yes, Your Honor.
Yeah, okay. That's why.
Okay.
All right. How much time did you need?
Just 2 weeks, Judge. And if
All right, Mr. Heelan, I'm going to adjourn your case out to May 14th, 2026.
Okay,
9
Your Honor.
a.m.
Thank you.
On continue. Call the public defender's office. They need to talk to you.
Okay, yes, sir.
You got that number?
Yes, sir.
All right. I want you to call it today so they have contact information.
Okay.
All right. Thank you.
Thank you, Your Honor.
Yep. Court calls the case. People versus Cecil Levine. Who? That's him?
Yeah.
Sit down. Oh, okay.
Sure. Oh, you want to sit down? Yeah, it would be okay if he sat. He's not feeling.
Oh, yeah, sure.
Thank you. Mike Getty, Assistant Public Defender for Mr. Levine.
Your name, sir? Thank you.
Your Honor, we'd ask to set these matters for a preliminary examination.
When you say these matters, I have,
This matter, my apology, Judge, this matter.
you have all discovery?
Yes, I believe we do, Judge. The May, I know Your Honor's been giving May 12th. I don't know if we could have a week later. He has a medical appointment on the 7th.
Any objection to that, people? Yeah, we can do it. All right. So preliminary exam, and people would have their witnesses available on the 19th. All right. Preliminary examination will be set May 19th, 2026, 9 a.m. That's before Judge Garwood. Is she paired with me? On the 19th. Judge Garwood.
Thank you. Your Honor, if I could be heard on a bond condition.
Sure.
Your Honor, Mr. Levine is currently wearing a tether. In the past, the court has allowed him to take the tether off for medical appointments, which he does have on the 7th. I have spoken to him, and he is going to be residing in Westland for the next foreseeable future, and we'll get that to corrections. I was wondering if the court would consider removing yes tether going to be some distance from the alleged or at the very least allow him to add tether for any medical appointments where he is required to not have it, such as MRIs and things like that.
Your Honor, I would be fine with the removal other for medical on the documentation is provided. We could do it by step. However, I would ask for it to remain on in the meantime, believe not.
I'm going to agree with the people on that. I'm not going to remove his tether. Currently, it will allow it to be removed for medical purposes, provided there's documentation regarding those.
Would Your Honor consider him just appearing at community corrections with the documentation, or do you want to stip an order each time?
For his medical appointments, I'd want to stip an order each time.
Thank you, Your Honor. All right.
Thank you. Court calls the case People versus Dejan Holmes.
Would Ann need this?
Assistant Public Defender Donavue Lebo for Mr. Holmes.
Is he here?
Your Honor, this is again a case where I expected my client to be here, but it does not appear that that is happening.
Bench warrant will issue defendant's failure to appear. Bond 10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls the case of the People versus Larry Mahan.
Alexander, on behalf of the people, Your Honor.
Michael Gaddy, Assistant Public Defender, on behalf of the defendant, Your Honor. I believe he's here by Zoom.
Yes, I thought.
Yeah.
Yes, I'm here.
All right. All right. So first, state your name.
Larry William Mahan.
All right. So first thing is, next time you appear, if you're going to appear via Zoom, can't be vaping in the courtroom. Understood?
Yes, Your Honor.
All right.
Your Honor, we're asking for a preliminary examination.
Okay. You have all discovered.
Yes, Judge.
And you have all discovery. People have their witnesses available at 12. All right. Set preliminary examination. This matter, May 12th, 2020. 9 a.m. before Washington. I would also indicate that there was a communication sent to the court, presumably from the victim. I don't know if that's where it came from. That's what it looks like. I will provide a copy of that to both counsel.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you. Court calls case People versus Deshaun McFarland.
Stephanie Hanna, on behalf of Mr. McFarland, should be appearing by Zoom.
McFarland?
Deputy F.
Now they ain't even turn around looking at me. McFarland? Cannon?
Sorry, Your Honor.
No, or really? Or not?
I'm sorry, Your Honor.
Couldn't even get that out in sincere fashion.
We're just asking for an adjournment. I know
I know, but he's got to be here. Not.
he,
All right. He gets called up in the next block because I'm not waiting.
I understand, Your Honor.
What's he gonna do?
He picked it up.
Oh, he picked it up after. Court does call the case. Armani Wardlow.
Levi Goldstein appearing on behalf of the defendant. What's your name, Mr. Armani Wardlow?
All right.
Your Honor, I am filling out a green sheet. I was just retained on this matter recently. And I have the written discovery, but I don't know if there are any videos because I have not been provided with any yet. So I'm asking for a 1 week adjournment.
1 week, I can give you 2.
I think to
the 14th.
14th. Let me check that real quick. Yeah, that'll work.
Yeah, I think we set some for you. May 14th, 2026, 9 a.m. bond continued.
And I've got a green sheet for you, Your Honor.
All right. All right, thank you.
Thank you.
All right, that's it for that block. You got to set up for 2. Then I'll come back.
This courtroom moment shows how one small decision can lead to serious consequences, even when it didn't have to. A defendant stood in front of the judge after violating a restricted zone, something that could have been avoided in seconds. The judge didn't yell, but made the reality clear. You spent 18 days in jail, and you didn't have to. As the details came out, it wasn't a case of bad intent, it was bad judgment. He entered a restricted area, didn't react quickly, and that one mistake triggered everything. The judge even explained the simplest solution. If you go in and the alarm hits, you leave immediately. No hesitation, no excuses. Because in situations like this, seconds matter. But what makes this moment powerful is what happened next. The judge acknowledged the mistake, counted the 18 days already served, and chose not to add more punishment. Instead, the bond was reinstated with strict conditions, tracking, and a clear warning moving forward. Because sometimes the lesson isn't about adding more time, it's about making sure the mistake never happens again. So here's the real question. When someone makes a careless mistake that leads to jail time, should the court punish further or consider the lesson already learned? Click like and subscribe for more real courtroom moments.